included in the grantor's estate. Now, in practice, what you'd end up doing is, in many cases, the life insurance is put in place to assist in the payment of estate taxes. So the transaction that occurs after death is the cash that's in the irrevocable trust goes to the estate or to the revocable trust and buys assets out of there or loans money to the revocable or estate in order to have the liquidity to pay the estate taxes. It should never say that it's the money, the life insurance should be used to pay the estate taxes of the grantor. Okay? Finally, I think this is the last one, crummy powers. Everybody knows what crummy powers are. That's the method that we engage in order to make a contribution to a trust be permitted to count towards the $12,000 annual exclusion. And the way that works is a person makes a contribution to the trust, and then a beneficiary is given the right to withdraw a certain percentage of that contribution, and therefore, if they have that time period to withdraw that money, it is deemed to be a gift of a present interest and qualifies for the annual exclusion gift. What happens if you have one of those black sheep beneficiaries that the big stick, little stick talk doesn't work? Everybody know what the big stick, little stick talk is? Here's this trust, I'm only putting a little amount of money. If you touch it, you don't get this trust with all the money in it. So most people understand once you explain it to them in that way. For those that don't, what happens if you give them that right to withdraw the money and they actually take the money out? Well, certainly in future years, you know, fool me once, shame on you. Fool me twice, shame on me. We don't want to give them the same opportunity to take the money again. So all the trust should allow the person making the contribution to designate who has the right to withdraw the money. So if I have 3 kids and 6 grandchildren, and I know one of those grandchildren will take the money out, I'm going to say when I give the trustee the check to pay the premium to make the contribution to the trust, just give it to these 8, don't give it to this one. The trust has to permit you to do that. So all the trust should say that the grantor, when making that contribution, should have the power to state who are to receive the crummy powers. Because if it doesn't, then the trustee is obligated to give it all proportionally, and you're going to have the black sheep have the ability to withdraw the money, which is exactly what you don't want to have happen. Any questions on anything I talked about so far? Yes, Martha.
There was a situation where the beneficiaries of the trust were not named as beneficiaries of life insurance policy. Actually, the life insurance policy named the beneficiaries directly and not through the trust.
Okay. No, it's not a problem, but you avoid the benefit of the trust. They'll just get the money outright. And
but somebody said that impacted the Goodman rule and that could be considered a third party too.
It impacted the what rule? I'm sorry.
The Goodman rule where it brought in a third party where you had the owner, the trust, and then the beneficiaries.
Yep.
And that would...
Well, what I perceive as the problem is not necessarily the fact that the kids or the beneficiaries won't get the money. I think you have a trustee fiduciary problem because the trustee designated a beneficiary incorrectly. Okay. And so I think that trustee can be in some hot water. Yes?
Stu, when you avoid the black sheep person, and you were saying the grantor can designate which one of the beneficiaries to receive the crummy letter, would that preclude you from using your exemption
for that person? Yeah, if a grantor chooses not to give one of the beneficiaries the crummy letter, you can't use their annual exclusion gift. That's correct. That goes by the wayside. All right. Oh, sorry, Steve.
What's happening? I mean,
what's the latest?
What's your latest?
Okay. The latest that I'm familiar with is that in the budget bills that both passed both houses of Congress, there contained a provision, and both were the same, where the exemption in 2009 at $3.5 million will remain, and the tax rate at 40% will continue. So 2010, for estate tax purposes, is never going to make it, and the $3.5 million exemption will continue. It's in conference now. Anybody that follows legislation that knows that once 2 bills get to conference, it's the big black hole. You never know what's going to come out at the end of the day. Both sides did pass it, and by a significant margin in both houses. It wasn't a party line type vote. Both houses passed it, and we'll see what happens. I really believe that's probably where we're going to end up. I think that I think that's what's going to happen. Nobody wants it to get to 2010, because then you get to 2011 where it comes back at a $1 million exemption. So even the Republicans, what I've read, have agreed that the repeal isn't really in play anymore, and it's all a matter of what the exemption is going to be and what the rate is going to be. Michael?
In monitoring the tax rates, has there been any talk as to what cap gains may revert back to? Question number one. And question number two, do you still think this Roth conversion in 2010 remains viable, or are they going to repeal it?
All right, first, what's going to happen with capital gains? It's an election year. Nobody is saying that they're going to raise capital gains right now. The thought that I've read is if the Republicans win, you're not going to see an increase. If the Democrats win, you will see an increase, but nobody's said anything about that. As far as the Roth conversion, it's on the books right now. It wasn't taken away in either of those budget bills, so it's there right now. I think you're going to see, you know, this year we got a partial relief from the AMT. I think you're going to see a much greater relief from the AMT in the future, and I think that's probably going to be tied in. Because whenever you have tax legislation, under the Byrd rule, it has to be revenue neutral, which means if you're cutting taxes, it can't be a negative on the revenue. So there has to be something that's given in order to make it zero out. So that, and along with a couple of other perks, is probably what you're going to see go if you end up in a situation where they're going to keep the capital gains or reduce the AMT or anything like that. Excuse me. Anything else? Thank you very much and appreciate your support.